Topic: Doctrine of decisis. Before understanding the doctrine of decisis, we must understand the common law system. One third of the world population, approximately 2.3 billion people, lives in the common law jurisdictions or in the systems mixed with the civil law. The common law originated during the Middle Ages in England, and from there was propagated to the other countries. The common law, also known as case law or the precedent, is the law developed by the judges through the decision of the courts and similar tribunals that decides the individual cases, as opposed to the statutes adopted through the legislative process or regulations issued by the executive branch. A common law system is a legal system that gives great precedential weight to the common law so that consistent principles applied to similar facts yielding the similar outcomes. The body of past common law binds the judges that makes the future decisions, just as any other law does, to ensure the consistent treatment. In cases where the parties disagree on what the law is, a common law court looks to the past presidential decisions of the relevant courts. If a similar dispute has been resolved in the past, the court is usually bound to follow the reasoning used in the prior decision. This principle is known as the stare decisis. If, however, the court finds that the current dispute is fundamentally distinct from all previous cases, calls a matter of first impression, the judges have the authority and duty to make law by creating precedent. Thereafter, new decision becomes the precedent and will bind future courts. The stare decisis, the principle that cases should be decided according to the consistent principle rule so that similar facts will yield similar results, lies at the heart of all common law systems. The doctrine of stare decisis. Stare decisis. Stare decisis is a Latin phrase which means to stand by decided cases, to uphold precedents, to maintain former adjudications. It is the general maxim that when a point of law has been settled by decision, it forms a precedent which is not afterwards to be departed from. The rules as stated is to abide by formal precedent, where the same points come again in the litigations as well to keep the scale of justice even and steady and not liable to waver with every new judge's opinion, as also because the law in that case being solemnly declared and determined was before was uncertain and perhaps indifferent is now become permanent rule, which is not in the breast of any subsequent judge to alter or swerve from according to his private sentiments. The being sworn to determine not according to his own private judgment, but according to the known laws and customs of the land, not delegated to pronounce a new law, but to maintain and expand the old one. Now, stare disease. The meaning of stare, the dictionary meaning of stare is see, and the dictionary meaning of disease is decisions. If an act of parliament uses the same language which was used in a former act of parliament referring to the same subject and passed with the same purpose and for the same object, the safe rule of construction is to assume that the legislature, when using well known words upon which there have been well known decisions, uses those words in the sense which the decisions have attached to them. The expression stare decisis means to abide by the decisions. It is the Latin phrase meaning to stand by decided cases, to uphold precedents, and to maintain former adjudications. The Latin maxim that goes to this regards is stare decisis et non quieta movere, as there were no reporting of the decisions of the courts, there was no doctrine of stare decisis. Article 141 of the Constitution recognizes this doctrine. It is binding on all courts in India except the Supreme Court, because Supreme Court of India is free to depart from its previous decisions for valid reasons like House of Lords in England. According to the doctrine of stare decisis, all the precedents of the Supreme Court of India are binding on all courts, including all high courts in India. Now, the general question is can the Supreme Court override its own precedent? The general answer is yes. Under the stare decisis rule, a principle of law which has become settled by a series of decisions is generally binding on all courts and should be followed in similar cases. This rule is based on expediency and public policy. Although this rule is generally followed by courts, it is not applicable in all cases. The reason is that the previous decisions should not be allowed to perpetuate a wrong. If the court is convinced that the previous decision is wrong, the rule of stare decisis is not so imperative or inflexible that it cannot be deprived from, but its application must be determined in each case by discretion of the court, and previous decisions should not be followed to the extent that the error may be perpetuated and grievous wrong may result. Now there are several case law in this topic. In Bachchan Singh vs. State of Punjab, similar view was expressed that the question of constitutional validity of the death sentence stood concluded against the petitioner by decision of a constitution bench of 5 judges of the Supreme Court in Jagmohan Singh vs. State of UP, and therefore it could not be allowed to re-agitated before bench consisting of the same number of judges. This plea was rejected by the Supreme Court, pointing out that though the general rule is necessary tool in which Maitland called the legal smithy is only useful servant and cannot be allowed to be turned into a tyrannous master. Here the Supreme Court relies on observations of Brandeis J. in State of Washington versus W.C. Dawson and Company, wherein it was observed that the stare decisis is ordinarily a wise rule of actions, but it is not a universal and inexorable command. If the rule was followed blindly and mechanically, it would dwarf and stultifying the growth of the law and affects its capacity to adjust itself to the changing needs of the society. Cardozo also was of the above opinion. The Supreme Court pointed out that in the present case there was a supervening circumstances which justifies a recognition of the decisions in Jagmohan Singh. One of the circumstances was introduction of the new criminal procedure code in 1973, by which a section 354 subsection 3 made life sentence the rule in case of offence punishable within date or in alternative imprisonment for life, and provided for imprisonment of sentence of death only in exceptional cases for special reasons. Now, the another case or the another case law supervening the circumstances was the decision of the Supreme Court in Maneka Gandhi versus Union of India, which gives a new interpretation to Article 21 and Article 14 of the Constitution. The new dimension of Article 21 and 14 render death penalty provided in Section 302 IPC read with Section 354 subsection 3 CRPC vulnerable to attack on a ground which was not available at the time when Jagmohan Singh was decided in 1973. Moreover, since Jagmohan Singh was decided, India had ratified two international instruments of human rights, and particularly the International Covenant on Civil and Political Rights. Under those circumstances, the Supreme Court did not follow the principle of stare decisis.